Hello, I'm Peter Rotskoff, Chief of Litigation and Professional Education for ARDC in Springfield. Today I'm going to give you 3 tips on how to avoid fee disputes in criminal cases. I want to preface the tips by explaining to you that we understand that in some cases, no matter how hard you work and what you do, clients in criminal cases are not going to be happy. We know from ARDC statistics that those who practice criminal law have a number of complaints, and we understand that. But the 3 tips I'm going to give you will help you to avoid trouble and hopefully help to avoid ARDC. The first tip is to confirm the fee in writing. Even if it's a flat fee or a fixed fee, it's helpful to have a fee agreement. If you don't have a fee agreement, at least confirm the fee in writing by sending a letter to the client. I can't tell you how many times we have clients or clients' family members who don't understand the fee or where the bond refund is going. And if there's a writing, there is no question about that. And if you have, for example, if you accept a partial fee and then allow for payments over time, that should also be confirmed in writing, as well as the consequences if the client fails to fulfill that part of the obligation. The second tip is to confirm the scope of the representation in writing as well. In many instances, the client may have multiple cases, they may have related traffic cases, they may also have potential civil litigation. So it's important that you confirm in writing exactly what you are representing the client on, and at the same time, if you're not representing the client in a matter, that should also be put in writing. For example, we have discussed the matter, and I am not agreeing to represent you in a potential civil case against the Springfield Police Department. That way, there will not be any confusion, and we have, from time to time, have clients write to us and say, my lawyer represented me in a criminal case, but he or she didn't pursue the civil case. And the lawyer will write back and say, that's because I didn't agree to represent the client in the civil case. So if you confirm that in writing, there will be no dispute as to what you've agreed to do. The third tip is to keep some time records, even if you are charging a flat fee or a fixed fee. If you're discharged from the case, especially early on, you may not be entitled to the full fee. You may only be entitled to quantum merit. And it's important that you have some records of what work you've done. The best way, I think, to do that is to keep some time records within the file itself or some other spot. The Illinois Supreme Court has never recognized a non-refundable fee. So if you are discharged early, you're going to have to establish the reasonableness of your fee under Rule 1.5, and that will require time records. So it's important that you keep some records of your time, and I think if you do it contemporaneously, it's a lot easier than trying to recreate that later on. For more information on fees in criminal law cases, how to avoid trouble, please view my full presentation recorded during the Hot Topics in Criminal Law in Illinois 2015 program and available in the ISBA online CLE archives.